Hi, welcome to this episode of Business Anywhere. And today we're going to be discussing why you should consider owning your significant assets in an LLC, both for asset protection and anonymity reasons. And we will discuss which state is ideal or which states are ideal for that sort of thing. First of all, let's discuss what do I mean by significant assets? And I literally mean anything that has any significant value to you. For example, if you have stocks and bonds, and I'm talking about taxable accounts here, obviously your IRAs and 401ks are held in a different way, but I'm talking about a taxable investment account like your stock portfolio, your taxable stock portfolio or bond portfolio. That type of thing. Real estate is always a significant asset. If you have any intellectual property, for example, any patents or copyrights for your business, maybe you have a business with equipment. A couple of years ago, I had a client in my tax consulting business who had quite a large landscaping company, and he had a lot of equipment, like heavy earth moving equipment, like tractors and backhoes and front end loaders and that sort of thing. A lot of very heavy duty expensive equipment. And so those things, in that case, we ended up creating an LLC only to own that equipment for him. And then that LLC, as the owner of the equipment, was paid a fee from his operating business to lease that equipment. And that allowed him to separate assets for asset protection benefits. That way, if his operating business was ever sued for any sizable amount of money, he's segregated out the assets of the business, and the operating business itself didn't really own anything. It was just the cash flow generator, which allowed him the ability to transition quickly if he ever did get a major lawsuit that he had to deal with. I'm talking about heavy equipment, stocks and bond portfolios, real estate. If you maybe do some debt financing, or you make loans out to friends, or you have some private equity investments, these types of things can be held in an LLC. And why would you want to do that? First of all, anonymity. If you're ever sued for whatever reason, personally, I don't know, usually the example I give people is if you have, let's say, a Super Bowl party at your house and one of your friends drinks too much beer, drives home, he's drunk, ends up hurting somebody on the way home, they're always going to sue everyone involved in that. And of course, you're going to get sued as well because your friend left your house with too much alcohol. I'm not making a case whether this is good or bad either way. It's just a silly example for these purposes, but you're going to get sued in that case if your friend hurt somebody. And in that case, the lawyer who is suing you, the claimant's attorney, is first going to do a record search to see what you own, to see if you have any sizable assets worth attaching in a lawsuit. And so what happens is they do a public record search to see if you own any real estate. They'll check around bank accounts. They'll check your credit report to see any assets you have listed on there, any debt that you have that would, like mortgages, paying off other assets, that type of thing. They can see this and make a determination whether you are a worthwhile target for obtaining a judgment. And if you don't have anything in your own name, you're basically, from the public record standpoint, you look poor, which is kind of an ideal situation. If you're going to get sued, you don't want to look wealthy, because then your claimant's attorney is going to see you're wealthy, and they're going to be very interested in coming after you. Just from an anonymity standpoint, having the appearance of looking poor, not owning anything in your own name, is always a great idea from an asset protection standpoint. And second, beyond the anonymity standpoint, also you do have a lot of legal protections if you own those assets in a properly structured entity, like a Wyoming LLC, for example. For example, let's say you do get sued, and now all of a sudden they find out through disclosure that you have $1 million in a stock portfolio that's held in a Wyoming LLC. Well, they're going to be limited on what they can do there, because the only thing they can do in the state of Wyoming is get what's called a charging order against you. And that charging order really is kind of like a wage garnishment in a sense. Basically, what it says is, as the LLC pays out distributions to you, it has to pay that charging order to satisfy your creditor. However, as the manager of the LLC, you can always just withhold a profit distribution that year. And then you're not required as an LLC manager to make a profit distribution. And so if you're not making one, then there's no profit distribution to pay off to your creditors. You get a lot of flexibility on how to manage those assets. And ultimately what that gives you the ability to do is to negotiate with your creditors and make a better deal. It's always, always, always a great idea to never own any significant assets in your own name personally. For these reasons. And that's why I think LLCs are one of the foundational tools for developing your own asset protection plan. Anyway, I hope this helps. Have a great day. Take care.